Hello, my name is George Saldana and I'm with Texas Team 2503. This is the grandmother I've been helping in San Antonio. I did not record this video, but somebody from Disruptive Media put it up on their YouTube channel. I watched it and it's horrible. And I'm gonna go over it. It's gonna be a play-by-play. So let's go ahead and watch. Please watch with me. So again, I did not record. This is with Judge Cynthia Marie Chapa in Bexar County. I don't know what court it is, but we're waiting as they get settled in. The reason I'm doing a play-by-play is because there's some key issues in here that I think some of y'all need to know about. Before this hearing started, the grandmother in which I've been helping has stated that she did not sign a Rule 11 agreement. That's one of the bigger issues we have. Again, this is going to be a play-by-play, so I'm going to let it play and then I'm going to stop and then we're going to go over some of the things that have been said. I'll show you the players as they come on. This right here is the grandmother, which I've been helping. This is her attorney, Sherry Dye. In here is Rasheen Mazahari. She's in court at the Bexar County Court. So she is by Zoom and Mazahari is in actual court. Now what y'all don't know is Mazahari was able to get a judicial hearing within like 20 minutes. There was no notice to the grandmother. The grandmother, Natasha Monroe, is in El Paso actively looking for the child she has been granted sole managing conservator of. So how did Mazahari get an emergency hearing to hear the dissolve of this writ of attachment? This is huge. Watch this video. You're going to learn so much more.
Good afternoon, everyone. Court's going to call cause number 2022 CI 08006 in the interest of ALM and child filed in the 45th District Court. Please make your announcements for the record.
Good afternoon, Judge Rasheen Mazahari. I represent Maribel and Louis Kell. I am present and ready. I believe my clients are on Zoom.
So, Attorney Mazahari is representing the babysitter. She's the one who took off with the child. The little history behind it is grandmother was in a contract between her daughter, who's the maternal mother of the child, and she relinquished her rights as the maternal mother to the child to her mother, which makes Tasha Monroe the biological grandmother and the sole managing conservator. Rasheen here is representing the babysitter. No blood relative, is not part of the family, picked up and just left with the child. They called San Antonio Police Department, and when they did, of course, what we always hear, it's a civil matter. So what did the mom do? The mom couldn't afford representation, so she relinquished custody to the mom, right? The grandma, her mother. So the grandmother is the maternal grandmother. Her modification and the petition was through the daughter and the grandmother. The babysitter has not filed anything into this case. So they're filing into this case right as she's looking for the child, and a writ of attachment has been filed. Now listen.
Yes. We are here. Good afternoon, Your Honor. Sherry Dye. I currently represent Tasha Monroe. She is present.
She's the grandmother.
On the Zoom as well. Yes, I'm here, Your Honor.
Thank you. What do we have today, counsel?
Judge, on September 2nd, an order to issue writ was rendered. That same afternoon, Ms. Dye and I entered into a Rule 11 agreement that the writ will not be executed.
Okay, so if you just heard what she said, and I'll rewind it just a second, you'll hear that Rasheen Mazahari stated that a writ of attachment had been ordered by the court on Friday, September 2nd. Then she calls each other and they come up with a Rule 11 agreement. And as you'll see, Natasha Monroe, who is the client of Sherry Dye, didn't even sign the Rule 11. So these two attorneys are making agreements without their clients. Watch.
I was hired to issue writ was rendered. That same afternoon, Ms. Dye and I entered into a Rule 11 agreement that the writ will not be executed.
And this is very important. She says, Ms. Dye and I entered into a Rule 11 agreement. At the end of this hearing, you will hear the judge say that the parties entered into a Rule 11 agreement. The parties didn't even sign this Rule 11 agreement. Watch.
I was hired and intervened in this case by my clients who have had the child since she was 5 days old. The child is 3.5. I have a.
So let's go back. The history of the case, yes, the alleged kidnapper / babysitter has been caring for the child since 5 days old. Not that she has been keeping the child since 5 days old. So the babysitter started care of that child at 5 days old. When she took off, of course, they called law enforcement. They said it's a civil matter. Let's go on.
Authorization agreement for non-parent relative or voluntary caregiver that the mother had executed in 2019. Unbeknownst to any of the attorneys in this case, Miss Tasha Monroe on her own went the extra step of getting a writ actually issued on September 7.
So if you hear, she said that the grandmother, Natasha, went the extra step to getting the writ of attachment issued. Okay, so her attorney threw her under the bus. She only did 3 things. She filed the motion for writ of attachment. She did an affidavit, which we'll talk about later. And she did, and they had an order of issuance for writ of attachment. Now, what her attorney didn't do is do the request for process service, the citation to actually have the constables or the sheriff's department hand out that citation. So basically, she did 3/4 of the job and she didn't finish it. But she decided to get with opposing counsel and file a Rule 11. So now opposing counsel is now saying, okay, we entered into the Rule 11 and grandma just went rogue trying to enforce the orders that the Bexar County 45th District Court gave her. Mary Lou Alvarez. Let's check it out.
Received the call from the El Paso sheriff this afternoon. I asked them to hold off so I can come to court. I explained to them that there's a Rule 11 agreement that we will not execute the writ. This case is set.
Hold on. Listen to what she just said. She says that she told law enforcement to hold off on the writ. This attorney has just interfered with a legal process. This attorney, Mazahari, told the sheriff's department to hold off on the writ. If that's not interfering with the legal process, what? She's not a judge, she's an attorney. While she can zealously fight for her client's rights, she still must be within the bounds of the law. And for her, when she found out that the writ was going to be executed today, she talked to the sheriff's department, told them not to do it, and scheduled an emergency hearing within 20 minutes. Check it out.
Miss Tasha Monroe on her own went the extra step of getting a writ actually issued on September 7. I received the call from the El Paso sheriff this afternoon. I asked them to hold off so I can come to court. I explained to them that there's a Rule 11 agreement that we will not execute the writ. This case is set for a hearing on Wednesday of this week, on the 14th. I'm asking the court to deny, dissolve, null, set aside the writ of attachment. It goes...
Whoa, she's asking the court because there's a hearing on Wednesday. The hearing on Wednesday is what's for all of this. They are trying to intervene into a closed case. Grandmother has already got sole custody. Grandma was already rendered sole custody. The case is closed. The daughter, the maternal mother of the child, relinquished her rights to grandmother. Nowhere is this babysitter has filed into the case while it was open. So now that grandma has the sole managing conservatorship of that child, now they're coming in and saying, whoa, we want a new trial, we want to challenge jurisdiction, and we want to intervene. So They haven't even intervened correctly yet. But let's go ahead and keep on.
Against our Rule 11. The reason we entered a Rule 11 is to avoid me having to file these motions, have a hearing on a writ of attachment, which was filed in the Sapsor case. A writ of attachment is a new cause. It has to get its own cause number, no citation issued to my client, no notice. There's a lot of jurisdictional issues. I'm asking the court to dissolve null and set aside this writ so that this 3.5-year-old is not any more traumatized than she is until we come to court on Wednesday.
Traumatized? This lady that she's representing isn't blood, isn't relation to the child, didn't even have a modification with the mother. And now she's traumatized because the court, the 45th District Court, Mary Lou Alvarez, rendered sole custody? The child is traumatized? How about the child shouldn't have been taken from San Antonio? Period. Now let's listen.
Your Honor, may I respond?
You may.
Good afternoon. So my client and I apparently have a differing opinion of what transpired for me to make the court aware. It was my understanding that she and I were in agreement. She did not sign the Rule 11. I'm going to ask.
She did not sign the Rule 11. How are these two attorneys making decisions? You have to remember, in the disciplinary rules of professional conduct, these are advocates for their clients. They are supposed to zealously fight for their clients within the bounds of the law. That doesn't give them open range, open freedom to just make some sort of contract without them knowing, right? And she even says it. Miss Monroe did not sign this Rule 11. So these two attorneys are making rules for their clients and the judge. But listen up, it gets better.
At this time to refrain from texting into the chat as it complicates matters.
What you don't see, and I'm going to rewind it a little bit more, is this.
Traumatized than she is until we come to court on Wednesday.
Your Honor, may I respond?
You may.
Good afternoon. So my client and I apparently have a differing opinion of what transpired for me to make the court aware. It was my understanding that she and I were in agreement. She did not sign the Rule 11. I'm going to ask her at this time to refrain from.
Tasha says, I did not sign the Rule 11. She's putting it in the chat, on the record.
We, I believe, had an agreement that this child would not be taken under the writ. She contends otherwise. She is aware that there is a court date pending. Because of the ineffectiveness of our communication, I do need to withdraw from this case.
Let me tell you something. On the 7th of September, I went with Tasha to meet with Sherry Dye. I was in the meeting the whole time. I recorded it. And I'll tell you this. There was no lack of communication in that hearing. But in a hearing where Tasha is telling the judge and telling counsel, I didn't sign this Rule 11, she kind of threw her attorney under the bus, right? Her attorney's not too happy with her, so now her attorney's trying to withdraw, saying, hey, I don't want none of this smoke. I need to get off. Okay, let's continue.
She did not sign the Rule 11. She is correct in that regard. We obviously have a difference of opinion as to the agreement of holding off. Ms. Mazahari contends that there are jurisdictional issues. My client was named the managing conservator. There was no one necessary to provide notice to other than her daughter, who executed a voluntary relinquishment, and the father of the child, who did so as well.
So the biological parents relinquished it to grandmother, right? That's the contract. That's that was the motion that was heard before the court. That was the order that was rendered, that grandma become the sole managing conservator. Now, as a conservator in the state of Texas, sole or joint or whatever, right? You have the right under the family code for care, control, and protection of that child. Them saying that grandma went rogue, went to El Paso to look for her child and enforce the writ, the judge from the 45th District Court, Mary Lou Alvarez, has already signed an order for issuance of writ of attachment. It was just this attorney that didn't complete the job. I went with Tasha to complete the job. We got the writ of attachment. And then Tasha right now is in El Paso driving back because El Paso Police or Sheriff's Department will not enforce the writ from Bexar County. And there's more, but we'll get into it in just a minute.
The work that Miss Kell, who goes by a different name as well, had. She certainly could have contacted my clients. She filed with the Attorney General availing herself to Bexar County, stating she lives in Bexar County, had a lawsuit in Bexar County through the Attorney General. It was non-suited shortly after my client was named as the managing conservator in the beginning of August.
Just last month.
She never made the Attorney General aware of her relocating to El Paso, nothing. She has not provided any family member, including the biological mother or my client, the biological grandmother, of her locating information. She has known how to reach them the entire time. And in addition to that, the maternal aunt resided with her and this child for a great long while prior to her leaving. So this child has not solely been in her care without family involved. She clearly knew how and would not allow any information to be revealed. And in fact, lied to the Attorney General, indicating that she was living in Bexar County when she was not. My client went to El Paso unbeknownst to me, and the court did grant the issuance of a writ. I imagine if she has the writ that she took it a step further. I cannot speak to that, but a writ was granted and entered. My understanding is that the writ of...
So the lawyer is saying that the 45th District Court did order the writ. So Mazahari saying, I didn't know that grandma was going to go rogue. Grandma has every right as the sole managing conservator, right? And I hope this judge is listening, but we already know that everything that has to do with preponderance of evidence, right? Whoever's giving to the judge's campaign, they're going to sway that way, right? Now let's go.
Attachment can be in the same cause number. It's the writ of habeas that needs to be different cause number. So she, the court did sign it. She went ahead and did that. So she is obviously withdrawal also to be granted, as obviously we have a difference of opinion as to the communication matters that are extremely important in this case.
So now the attorney Sherry Dye wants to withdraw because there's a communication problem. Yeah, there is a communication problem. You just filed a Rule 11 without your client's signature, and you made a deal with opposing counsel. And you didn't even tell your client about it, or your client didn't even understand. If the communication is lacking, it's coming from the legal professional trying to do some squirrely stuff.
Signed the Rule 11, Your Honor.
And Judge, the rules don't require a party to sign a Rule 11. The attorneys sign because I didn't want to go through the extra cost of setting aside a writ. If I knew...
So she just said the parties don't require, or the Rule 11 doesn't require the parties to sign. This is dangerous, folks. This means basically your attorney can sign anything on your behalf when you're the client. Again, the disciplinary rules, professional conduct say these two are advocates for their clients. They don't get to just call the shots. The clients are the ones paying. The clients are the ones asking for a certain service. You don't just get to put in their order as you deem necessary. Let's go on.
That, and obviously Miss Dye didn't know either, but if we knew that grandma was going to go rogue, then I would have gone through those steps. But as an attorney, I should be able to rely on a Rule 11. We're asking you to dissolve the writ and set it up.
As attorneys, we should be able to rely on a Rule 11. Does anybody see the issue with that? Wow.
This 3.5-year-old. What is
Honor, Wednesday?
Plea to the jurisdiction, motion for new trial, subject to a special appearance.
So Wednesday, I'm going to ask for all the court watchers to watch this, because Wednesday, they are going for a plea to jurisdiction, right? Saying that the child has lived in El Paso this long. We already know there's some lies in that, right? And we're addressing it. 2, They want to go to be able to intervene into the case, right? They want, the case is closed out. It's already rendered. It's already done. They signed it off that grandma was the sole managing. Now somebody who doesn't have any blood ties to this child is trying to intervene at the very last minute, trying to say, hey, look, guys, I think I should have custody of the child. If she's had the child so long, why didn't she file for a petition earlier? If she's had the child in El Paso so long, why didn't she move jurisdiction? Why? Because she never had any type of conservatorship for the child. Here we go.
Do you agree that's what's said first? Hold on one second, Ms. Moon.
Thank you.
Do you agree that's what's said, Ms. Dye?
I agree that's what is set, Your Honor. I also would ask to set my withdrawal prior to that time, or to allow me to withdraw prior to that time, because
Tasha says she did not sign a Rule 11.
And I'm not going to object to that. That's between her and her client. I'll sign any order.
Okay. Ms. Monroe, did you ever at this time be to ask her if she has any?
So this is Grandma, Tasha Monroe. I've been helping. And this is the alleged kidnapper, babysitter, who has no blood ties to the child. Here's the judge.
Concerns with you making a statement prior to due?
For my counsel? Actually, I mean, I'd like to make an oral motion to have counsel withdrawn. Let the records show that there's also dishonesty, not only, it's between, I feel like she's dishonest with me. I don't feel like she has the best interest of me or my family at heart.
Any objection to the oral motion for withdrawal?
I don't have an objection to the oral motion if Ms. Dye doesn't.
Ms. Dye, any objection to the oral
No.
motion?
no, Your Honor.
You do agree, Ms. Monroe, that you no longer want counsel. You do understand that there is a setting for the 14th that is not going to be reset. Do you understand that?
So today's Monday. They got a setting in 2 days. She just decided, hey, I don't want counsel. I don't think they have the best interest of my heart. Now the judge is making her go into that proceeding without even looking for a new counselor, not even looking for a new attorney, right? She just fired her attorney on the spot, and while she's legally able to represent herself, right, in a court of law, she also has the right to obtain a lawyer. And this happening in 2 days, Mazahari is a powerhouse in San Antonio. She's taken children from other people. We're on to her. I know about her, right? So this already sounds squirrely again, but keep listening.
I understand that. I'd also like to state that I am the legal custodial parent of this child. That's why I've executed the writ. There was no orders
Hold
that
on.
I
So look at the judge. Hold on. This is a common tactic that judges use. Judges like to tell you to hold on, stop, or try to redirect you to keep things off the record, right? Because if you spill case law, if you say certain things, it's all being recorded, right? And so this judge, just like my judge did, they like to walk over you and silence you when you're trying to make a statement, for the record. So let's go on. I'm going to go just a little bit right there. We'll start.
I am the legal custodial parent of this child. That's why I've executed the writ. There was no orders
Hold on. I'm not asking you to go into anything. I'm asking you to answer the question I'm asking you. Do you understand that there's a setting for the 14th in this matter, and that it's going to proceed right
Yes,
now
ma'am.
without counsel if you don't have counsel?
Yes, Your Honor.
I thought we went over that already. That she
Your Honor,
made
if I
her.
may just put something on the record. Ms. Monroe is named as the managing conservator, the sole managing conservator of this child. She is correct in stating that. She has been provided by email a copy of Ms. Mazahari's motion for the 14th, and she is in receipt of that.
That was her attorneys talking in
And
the
Judge,
background.
that order was rendered on August 5th without notice to my client, who's had the
Without notice to her client. Her client's not even in the party. Her client wasn't even invited to the party. The parties are the daughter who relinquished the rights to her. How is this even? Look, she got a smile on her face. This is grandma blood to her child. That's her granddaughter. If you have sole managing conservator, law enforcement's not helping you, this is the crap that the judges are putting out. Why didn't they just call the 45th Judicial Court and ask Judge Alvarez, since she knows the history of the case, on what's going on? But no, we got a new judge. Mazahari did it in 20 minutes.
Possession of the child. That's the motion for new trial is for the order they're talking about. It's a brand new order.
Okay. All right. The court is going to accept the oral motion for the motion to withdraw counsel. The court's going to grant the motion to withdraw and allow Ms. Dye to get opposing counsel the order and have Ms. Monroe sign on that order. Please make sure to sign the order when it's provided by Ms. Dye, so that way y'all don't have to come in on a motion to enter.
So she's giving more orders out. You're having orders on top of orders on top of orders. Now you're having orders that supersede the 45th District Court, who just gave her sole managing. Some orders are good and some orders are bad. What's the problem? Why do we have orders of the court if they're non-enforceable?
Releasing her and her obligation as your counsel, Ms. Monroe. At this time, there is a Rule 11 agreement that was given between the parties that is going to stay in place, so the writ is going to be set aside.
Okay, now listen to what the judge just said. There is a Rule 11 between the parties. The attorneys are not the parties. The attorneys are the advocates, are the attorneys for the parties. Here we go. Listen again. There's a Rule 11 for the parties. Absolutely not. Grandmother didn't sign. Kidnapper didn't sign. Only the two attorneys that are trying to prolong litigation signed. If they would have enforced the writ, if her attorney would have enforced the writ, the child would be safely with grandmother, whom the 45th District Court, Mary Lou Alvarez, has signed off for it to go to, right? She signed off on the writ, and she signed off on the motion for or for the sole managing conservator, right? Now they're trying to muddy the waters. It's called forum shopping. Let me go find a judge that will hear my case. And Mazahari must be absolutely great at it, because what did she do? She got a hearing within 20 minutes. Nobody notified. They notified Tasha within 10 minutes that she had to be on by Zoom. And so here we go.
Monroe, sign on that order. Please make sure to sign the order when it's provided by Ms. Dye, so that way y'all don't have to come in on a motion to enter. Releasing her and her obligation as your counsel, Ms. Monroe. At this time, there is a Rule 11 agreement that was given between the parties that is going to stay in place, so the writ is going to be set aside. We're going to have a hearing on the 14th at 9.
So now they're setting aside the writ of attachment. The writ of attachment is when the police go and grab the child and bring the child back, or give it to the person who's supposed to have possession, right? It's a little different from a habeas corpus. But now she has set aside that writ of attachment. What does that say for these courts here in Bexar County? I'm going to give grandma sole managing conservator, but when she tries to go and enforce her orders, when she does a writ of attachment, nothing is done. We're just going to retract what we just did. Not only does it prolong litigation, but now everybody is paying the lawyers. Who's getting paid? The lawyers and the judges. And campaign contributions on winning stuff, it just makes things a lot messier. Listen.
9 a.m. the parties are ordered to appear, and y'all can address all those issues at that time at 9 a.m. in presiding. Do we understand that?
And Judge, clarification, appear by Zoom is okay, or are you requiring personal appearance?
Right now, I think y'all can appear either way, however you choose to appear, but
Yes.
I'm ordering that the parties appear.
Thank you, Judge.
Your Honor,
Yes, ma'am.
okay, I understand what you're saying, but I also like to note that the only reason why I have not seen this child and she's had care is because she's been keeping her away from us. But yes, I would be okay with representing myself.
Okay, do me a favor. If you have concerns about visitation or all that stuff, Ms. Harry is the attorney, so you'll have to reach out to her or reach out to new counsel to discuss that, but you'll have to contact her to talk about possession, access, visitation.
She said if you have issues with possession and access, talk to attorney Mazahari. She's already been giving sole managing conservatorship. Where does she become where does she become the person who has to ask for permission to see the child? She has legal documents stamped by the 45th District Court and the district clerk that says she's the sole managing conservator. Isn't this weird? That now they're saying, oh, if you want to see the child, you need to get with opposing counsel, Malzahari.
Whatever needs to be done, if you're gonna try and reach an agreement prior to Wednesday, okay?
Even if I have sole custody?
As of right now, y'all are set for Wednesday, so y'all go in on Wednesday.
She doesn't want to address it.
Yes, I understand that, but already, I mean, I've already been rewarded sole custody of the child.
Ms. Monroe, I'm asking you to show up on Wednesday. If you want to reach an agreement or try and discuss this case with Ms. Mazahari between now and then you need to reach her. Do you have her contact information?
I do not have her contact information. I don't understand. I'm a little confused as to why I need to get with Ms. Rasheen in order to get visitation when I have sole custody of the child.
Exactly.
I should be able to pick her
I
up.
can't give, ma'am, I'm not going to argue with you. I can't give you legal advice. You had counsel, you asked for that to be withdrawn. So
So here how the judge is making grandmother, the sole conservator, the aggressor. She has every legal right for care, custody, and control. She's the only person who has care, custody, and the control, right? She has no orders whatsoever. And now the judge is saying, I can't give you legal advice. You just broke up with your attorney. You don't need legal advice. It already says on an order. Tasha is not asking what I should file. Tasha is asking, why are you doing this to me? Your court across the hallway here at Bexar County Courthouse has already ordered sole managing conservator. Why are you doing this, right? So apparently, no matter if you have sole managing conservatorship, this is what happens. And it's hurtful, not only to the child, it increases litigation. There's zero judicial economy, zero. And guess who's making all the money? The attorneys. Is this really in the best interest of the child? Let's keep going.
when seeking counsel or contact opposing
information, I don't understand. I'm a little confused as to why I need to get with Ms. Rasheen in order to get visitation when I have sole custody of the child. I should be able to pick her up.
I can't give, ma'am, I'm not gonna argue with you. I can't give you legal advice. You had counsel, you asked for that to be withdrawn. So go and seek new counsel or contact opposing counsel and have that conversation. I can't give you any more advice than that.
Wow.
Thank you, Your Honor.
Wow. No custody order, custody order.
May we be excused?
You may.
Thank you.
You have one more question for clarification.
So they're at the sheriff's department. They took the kid to the sheriff's department. She's in El Paso. She's been trying to enforce her orders at that sheriff's department. The sheriff's department won't enforce her orders because they're from Bexar County and they can't authenticate them, right? So she takes the kid, the babysitter takes the kid to the sheriff's department. I'm going to back it up just a little bit, right? 10 seconds. And she says, I'm at the sheriff's department. Perfect opportunity for these law enforcement officers to take the child. And this isn't a civil matter because it's between joint managing conservators, right? This lady has no orders. This lady has sole custody. It's not a brain teaser. It's not rocket science. Where's the child supposed to go? With the sole managing conservator. But instead, El Paso Sheriff's Department helps somebody who doesn't even have court orders. Now you talk about trafficking. You talk about all the things that happen to children, right? They could be sold. Child could be across the border in New Mexico. And law enforcement does this.
Excused?
You may.
Thank you.
You have one more question for clarification. We're at the
Can
sheriff's
you
office.
text me? Marbell, text me. Judge, can I grab the order to get a certified copy so I can send it to the sheriff?
So did you just hear that? Let me back up 10 seconds, right? She says, can I get an order so I can submit it to the El Paso County Sheriff's Department? What makes Mazahari's orders so much more special than the conservator, the sole managing conservator's orders. I thought they couldn't enforce those orders because there's Bexar County. So obviously there's a bias. I'll help an attorney as long as she gives me orders, but I'm not going to rely on the litigant or the parent or the sole managing to bring certified court orders. We live in a world of technology. We have iPhone 14s right now. We can look at the moon. We can see rockets flying off into space. But we have a court-ordered judgments that are still on paper. There's no chip, there's no barcode, there's no QR code that says, hey, this is a valid order. So again, it shows that Mazahari asked, and we'll go back just a little bit, where she's...
Text me, Marbell, text me.
Listen.
Judge, can I grab the order to get a certified copy so I can send it to the
Yes,
sheriff?
ma'am. I'm just making a
Thank you.
So she can get a certified order to send it to the sheriffs. So everybody's talking about Texas Penal Code 2503. Again, I didn't record it, but I did watch. But that's the show that was had today in Bexar County. This is just, what do you have judicial orders for? What do you pay attorneys for? So they can lie, so they can make backdoor deals behind your back? She's in the police station. You have a judge. Nobody is upholding the law. Your fundamental rights to your children are gone. It just shows that somebody can pick up the child, a judge can render orders, and nobody will help you. This is the problem we are trying to expose. Thanks for watching.